And my lady, with your permission, I'll then wish to submit, my lady, as follows. My lady, you shall note that this matter before you have a checkered history. And that more particularly, my lady, you shall note that the first petition was filed before this court in the year 2020. Together with the others, my lady, which are filed in the year 2021, all of which was certified as urgent by this court. That determination of urgency, my lady, has never been set aside today. The record will again bear me out that the petitioners, and by the ruling of this court, the petitions were held to raise substantial constitutional issues that led to the empanelment of this court. And lastly, the record will also bear me out that various courts issued conservatory orders based on the material that had been placed before the courts. And which orders, my lady, continue to be violated to date. The record will also bear me out, my lady, that the petitioners filed contempt proceedings before this court, all of which were also certified as urgent. Again, my lady, my lords, in both the petitions that were filed by the petitioners as well as the contempt applications, the petitioners have filed written submissions in all their pleadings. What the petitioners have been seeking before you is that they simply seek a date for highlighting their submissions. For the last 2 or so years, my lady, that has been our prayer before this court. And the court will bear me out that the reasons that have always led to the non-prosecution of those proceedings have never been at the instance of the petitioners. You shall not, and my lady, the record will also bear me out, on the previous conduct of both the cited contemners and the respondents. The single purpose have always been delay, delay, delay. None of them have always ever been ready that this court opens the page of the contempt proceedings. At one point, my lady, this court ordered that all the pleadings, all the petitions and applications be had together, back to back. They went to the Court of Appeal. And they secured a stay of this court's proceedings. My lady, you shall note that we are here where we are pursuant to a direction of the Court of Appeal, that this court first determines the question of legal representation. My lady, that ruling was delivered by yourselves on the 31st of October last year. The consequential effect of that ruling, my lady, my lords, was that then the parties were at liberty to proceed to the next steps in concluding the proceedings before this court. And what are we being informed today, my lady? That there have been 4 applications before the Court of Appeal, all set to achieve one objective: stay the proceedings or disrupt the proceedings before this court. For the record, none of the petitioners that we represent have instructed any council to go before the Court of Appeal to file the purported applications. And you shall note, my lady, that although my colleagues have referred to 4 applications that have been filed, we were just last week served with only 1 application. That is application 618 of 2023. All the other applications that my learned colleagues have referred to, we have not been served. We even do not know the contents. But what then is the key thing that this court ought to note as it considered the submissions by learned colleagues? Firstly, my lady, my lords, is that the Court of Appeal has not granted any stay of the proceedings before it. And without a stay, my lady, my lords, this court cannot comply with an order that has not been given. The Court of Appeal may or may not grant that prayer. And therefore, it will be premature, even for my learned colleagues, to bring the issue of the Court of Appeal before you. In any event, none of them have had the courtesy of even submitting a copy of that application to this court if it were to be considered as a factor to grant an order of temporary stay for the 90 days that have been sought. This court cannot operate in a vacuum. And I urge, therefore, my lords, that you ignore those submissions. We have no doubt that the ruling of this court of 31st of October 2023 was based on a sound constitutional legal foundation that the Court of Appeal would have no reason to interfere with. But we'll meet our colleagues before the Court of Appeal. My lady, my lord, you shall also note that there's been no application for review of those orders or ruling that have been filed before you. Neither have this court by itself set aside the orders that it granted on the 31st of October 2023. It's straight law, and all of us are aware as lawyers, that once a court has made a determination on an issue, then it becomes functus official. So on matters legal representation, with respect to my learned colleagues, including senior counsel, this court has no jurisdiction whatsoever to grant any order in respect thereof. And neither can the question of legal representation that this court resolved be invoked to stay or postpone the proceedings before you. The ink is already spent. This court has spent judicial time in determining that point. And it cannot be invoked again as a point or a ground of adjourning these proceedings. My lady, my lords, the prayer that we were making before you today, before the confusion was invited into the proceedings, is as follows. That whereas this court asked parties to consider mediation, no party was compelled to participate in the mediation process. We ourselves, in compliance of the court order, volunteered ourselves to the process. But before I could conclude my submissions, my learned colleague interfered. I was just disclosing to the court that my client's board of directors, a section of my client's board of directors, made the cabinet secretary. And it's a fact. And the cabinet secretary promised to undertake the issues. And facilitate a resolution. That is a fact. As
annexed mediation. We are in no way to blame for that process not having taken place. It's not our blame at all. Because as this court is aware, when the court directs a court-annexed mediation, the next step is for the court to appoint the mediator. And we get letters from the mediator. We have not received any letter from the mediator. Number two is to ask this court to bear in mind that what is before this honorable court is directions in respect of the matters listed. And therefore, the issue, for example, of contempt is not before this honorable court. And when it is brought, we will be able to demonstrate there is not, and there has not been, any contempt. Number three, within my 5 minutes, is that it will be mission impossible for the mediation or this court to proceed any further without the issue of representation being finally resolved by the Court of Appeal. For the reason that Milimo, who continues to enjoy the orders of this court, that is the one to represent KTDA.
My Lord, I'm not enjoying the orders.
The one you
My colleague, well, he has every right to use those sweet terms. I know the media is there, but it's not me enjoying. It's the clans who are granted orders which are legitimate and on merit. There's nobody who's enjoying the orders. And in any event, he should be the one. If he's representing the petitioner, they are the petitioners who are enjoying the orders. It's not Milimo. So for him to mention me, let him mention the parties before the court.
Your Ladyship, my lords, I'm asking this court to bear in mind when making these directions that the farm of Milimo Muto was given instructions by the former board of directors. No, it's, but your lordship can allow me to mention why it is important for the Court of Appeal to resolve that issue with finalities, and why it is important for this honorable court to give a bit of time to the Court of Appeal. When we appear before this court, for example, the Court of Appeal does not want to, if this court does not want to give time to the Court of Appeal, does not give a bit of time to the Court of Appeal to resolve the issue of representation, and gives a date for hearing for these matters, we will be before your lordships. And I pointed out, for example, that my learned friend Guadaro Thoita here represents 40 tea companies in terms of the orders of this court on the 31st of October. So you'll be coming here representing those tea factories on the instructions of the board in office, saying the opposite of what you'll be being addressed by the instructions given by the former board, which I understand this morning that former board, which has not been in office for nearly a year, went to see the minister. So this is a confusion that a final determination by the Court of Appeal is going to resolve, so that whichever farms are decided by the Court of Appeal will come and address this court with finality. Well, it's the hierarchy of our courts. Well, no, I legitimate point, and I concede. But I'm saying the issue of representation is so core in the proceedings before this court or before the court annexed mediation that it really has to be resolved first. So I urge that the most logical issue in terms of Article 159 of the Constitution is for this matter to be mentioned again in 90 days.